here by the time you were on the phone. We have Representative Tony Klein here, and I am here, but we're still waiting for Senator Lyons and Commissioner Recchia. So while we're waiting for them, will you have any better or some idea of your availability in the coming weeks? Or should we shoot you a number of possibilities that the working group comes up with by email?
The second alternative would be never.
Okay, great.
I'm here in St. Albans until the end of the month. Then after Labor Day, I start an assignment in Burlington.
Somebody should, better video would be over there.
Go over there. I just want to show you the stuff. So I can label what's in the bank that's still
If I know enough in advance of when people need me for meetings, I can send the list to my clerk.
Look at this.
Say, you know, can you free me up for any
that's the end of it.
Okay, that's perfect. Then at the end of the meeting, when we've
This
gone
is
through
another one
that,
for context. See,
one of
all
us
this
will be in
water is
touch.
flowing down there, and it's
Great. In the
overwhelming.
meantime,
That's that
Senator
wetland
Lyons is
above it.
here. We have Judge Mello on the phone.
Herbicides,
And
next to
we're
the
waiting
water
for
features.
Commissioner Recchia.
Dead trees.
Just so
This
you
is
know,
completely destroyed.
I have read
Dead trees. Okay, I just want you to see what we got.
Okay.
the bullet points,
I saw
slide presentation.
some of it online.
I've read the notes on the slide presentation, and I've read Judge Bryce's decision in the Barron case.
Great, thank you. And we'll be, my plan, subject to the working group agreement, is to take minutes today and share those with everybody too. Is anyone here from the department?
They're coming the furthest, so that's why.
Yeah, that's why they're late, because they're on this floor. Well, in the meantime,
I should move down there for video.
do we have those agendas? Yes.
Sit next to June.
While we're waiting, we have a proposed agenda subject to approval by the group, which will pass out. We have members of the public in the room too, who can have these agendas. And we also have a sign-up sheet. I think it's going around. And please put your name on the list. That will help keep you in the loop. And the department just showed up.
Hello. Yes, we did.
And
We had a long way to go.
we have Judge Mello on the phone. So with the arrival of Commissioner Recchia, the working group is here. And Judge Mello, because of his court schedule, can only be present with us from 10 to 11. So, and as you may have heard, I did email him the slides for today's background presentation, as well as the notes that I'm using to speak to those slides. And does everyone have a copy of the agenda? With everyone here, I'll call this to order. I'm Margaret Cheney. I'm a member of the Public Service Board. And if the members of the working group have been appointed by, as required by statute, and you can see on the agenda the exact words of Section 15B from Act 174, which was Senate Bill 260. And we have a charge in number 1 to review the current processes. We have until December 15 to submit written recommendations. And we have the help of the Public Service Board staff. And I, as the appointed member of the Public Service Board, am to call the first meeting of the working group. We will try to, as required by statute, have it occur on or before July 1st. We were not able to get every member of the working group available, despite many attempts. So, and as you can see, we could not have everyone physically present for today. today, but we do have Judge Mello on the phone. And so I think we should start with introductions. And why don't we start with the working group members?
I'm Representative Tony Klein, Chair of the House Natural Resources and Energy Committee, and was appointed by the Speaker of the House to serve on this.
Senator Ginny Lyons, member of Finance Committee in the Senate, as well as Joint Energy Committee, and was appointed by the Committee on Committees to this working group.
I'm Chris Recchia. I'm the Commissioner of the Public Service Department. By statute, I was to appoint me, my designee, and appointed myself.
And Judge Mello, you're next.
I'm Bob Mello. I'm a Superior Judge. I was appointed 6 years ago. I'm presently the presiding criminal judge. I'm the presiding judge in Franklin County. My primary task is a criminal docket. Starting in September, I'll be the presiding judge in the civil division in Montpelier.
Great, thank you. And I, as convener of this meeting, I thought it would be a good idea to hold it first here in the Public Service Board hearing room so we can have a sense of where our hearings take place. And we also have our offices upstairs on the 4th floor. At some point, it might be interesting and useful for people to see our offices and get a sense of who's up there. And on this floor, we have the Public Service Board hearing room, but also the offices of the Department of Public Service, which also have offices on the 2nd floor. The building is also occupied by the People's United Bank on 2 floors and offices of the Judiciary on the 5th floor. So this is it's not a government building per se. So our first task is to elect a working group chair, and then I'll hand it over to that chair. I did prepare a PowerPoint presentation so that everybody would have a basic starting understanding of how the Public Service Board operates and all the various types of cases and procedures that currently are in place. So, but I think that after we elect a chair, then the group, I think, should choose to approve the proposed agenda and move on from there. Tony Klein.
On that light, I would move to nominate Senator Lyons to chair the group.
All right, we have a nomination of Senator Lyons to chair the group.
I will second that.
Second by Commissioner Recchia. Are there any other nominations? Then
I would move to close nominations and cast one vote in favor of Senator Lyons to chair.
all right, we've got the nominations closed. All those in favor of Senator Lyons chairing the working group, say aye.
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 Well, thank you.
It's all yours.
This is going to be, I think, a terrific opportunity to work together on the issue. I know that there's quite a bit of discussion in the State House, but and there are other things happening. So I think what the task before us is to look and see what Public Service Board is doing, and then to look at what else is happening, and we can talk about that a little bit later. But thank you. I think we'll soon find out. But we do have a draft agenda, and we have looked at this as a group. And so I would ask for approval of the draft agenda. Does anyone want to make any changes at this point, folks on the working group?
I would just say we introduced ourselves at some point. It might be a good idea to introduce people in the room. I did put a sign-up sheet around. But
so we can do that, and
right.
we'll do that after we've had an opportunity to approve the
Right.
agenda, and then we'll just go around the room and see who's here. Be good. Thank you.
I would move the agenda.
Okay.
second,
All right. Any additions, changes like to make? I think it's a good first start. All right. All in favor?
aye.
Aye. Opposed? Judge Mello?
Aye.
Terrific. Thank you.
And Judge, can you hear us okay?
I can hear you fine.
Great, thanks.
You know, Judge Mello, we're going to go around the room and have folks introduce themselves, and then I think, how long is the PowerPoint, Margaret?
Let's say maximum 30 to 45 minutes.
Okay. I might ask Judge Mello to give us some input about his thoughts for future meetings a little bit, because he won't be here for any of the discussion that we have later.
Right,
But I'd
and
like to
he
comment.
did mention that it would be helpful for us to email him our thoughts on when we might meet, but I think what you're implying is that what we might...
Topics.
Topics.
Well, and we can all do that.
Right.
We'll all be doing that, and we can, and we'll be pulling in folks to help us with that. So, good. So let's go around the room and see who's here. And we'll start right behind
Sure.
Margaret.
I'm Ann Bishop. I'm the Public Service Board's chief economist, and as you'll hear a little bit later, I'm also heading up the board's staff team that is implementing the board's new electronic case management system that's called EPSB.
I'm Greg Pierce, a private citizen. I live in St. Albans. I have interest in the wind, sound, and other problems associated.
Jeffrey Commons. I'm the Director of Public Advocacy at the Public Service Department.
And why don't we go to Andrew?
Sure, I'm Andrea McHugh. I'm an analyst and hearing officer for the board.
Good morning, I'm June Tierney.
Or did we skip someone?
Steve
Oh.
Whitaker,
Steve Whitaker?
citizen.
Okay.
Oh, and may I just interject? The camera is...
That one's Orca's, this one's mine.
Okay, so and can you tell us where your, you will be sharing this?
My camera, I load it into Google and don't index it worldwide, and I make it available by link to whoever asks for it.
And since we're on cameras, may I ask if we could also ask about this camera?
Oh,
Hi, I'm Ivan Shaddison with Orca Media, the public access channel in Montpelier, and this will be available on orcamedia.net if you want to share this footage.
thanks.
And we have emailed the slides to them.
Good. Terrific. All right.
As I was saying, I'm June Tierney. I'm the General Counsel for the Public Service Board. I'm a colleague of Ann and Andrea's, and I work regularly with Member Cheney.
Okay.
Good morning, John Brabant. I'm here today to represent Vermonters for a Clean Environment, and I'm also videotaping.
Good morning, Shana Loisel with Vermont Electric Power Company, the communications and policy advocate there.
Hi, I'm Olivia Campbell Anderson with Renewable Energy Vermont.
I didn't hear you.
Olivia with Renewable Energy Vermont.
I'm Chance Eggert with Renewable Energy Vermont.
I'm Chuck Storrow from KSC Partners. I'm here on behalf of our client AT&T, and I'll probably share my report with our client Green Mountain Power.
I'm Jane Palmer from Moncton. I'm here as a citizen and as a intervener in a docket 7970.
Hey, Palmer. Just here just because it's so much fun to be here. Didn't want to miss the opportunity.
Do you have a special interest?
We've been through the 248 process
Okay.
due to the fun little pipeline project.
Thank you.
I'm Dick Fogal. I'm the Executive Director of Middlebury Community Television. I've been covering public meetings since 1989. I'm obviously not running a camera today, but we have other people who are doing it, so I'm just here to represent other PEG access stations and answer questions if necessary.
Annette Smith, Executive Director of Vermonters for a Clean Environment.
I'm Ed Ribka. I'm a private citizen who's intervened in a Section 248 proceeding. And I've come here and I've also prepared some written recommendations that I would like to submit to the board if they were willing to accept it later on.
So remember, we're a working group. We're not a board.
Pardon me, the working group.
So, well, we're more like a legislative group, and we'll talk about that a little bit later. But thank you for your input. We'll get that. Carol Irons, citizen living in Albany, and seeing some of the direct impacts of industrial wind on the land and the people. And your name is Carol Irons. Okay, thank you.
I'm Keith Ballack. I live in Sheffield. I chair my town's planning commission, and I've always had an interest in what's going on for the past several years, the impacts of these energy projects.
Okay, good. A lot of interested parties. And so And remember, I think what's really important for each of us to keep in mind is our charge here is to make recommendations to promote increased ease of citizen participation in the proceedings before the board. But so the first step to help us will be to look at what currently happens, and then we'll move on from there. And then we're going to ask Judge Mello for his sort of quick thoughts.
In case the PowerPoint presentation goes past the time Judge Mello needs to get off the phone, should we consider generally what types of topics the working group might cover in case, Judge Mello, you have any ideas?
Do you want to give us some of your ideas, Judge Mello, right now?
Sure, I'll be happy to.
Good.
One thing would be helpful to have would be contact information for all the members of the working group. It would also helpful to see electronically a copy of Act 174 and to receive electronically copies of whatever rules, regulations, procedures, processes the board already has in place with respect to citizen participation. I assume there are some written materials in that regard. And it would be helpful to know, since I'm apparently the only person on the working group who does not have experience with how this working group came to be, it would be interesting if to hear from another member of the working group, perhaps you, Senator, why it is the working group was created. What problem, was there a problem that occurred, that arose, that prompted the legislature to ask us to look into this issue?
Good question, and I am not prepared to go through a description of that today, but certainly that is a very valuable piece of information. We'll do that. We'll put that on the next agenda.
Thank you.
Good. And your other suggestions are very helpful. Do we have the rules and procedures? Can we get those electronically?
Yes.
Okay, so we could get all of those.
Yes.
Terrific.
And Judge, this board staff said yes.
So we can get all of the things that you've asked for electronically, and then we'll have some type of presentation on how Act 174 came about. Okay?
Thank you very much.
You're welcome, and thank you. Okay, that's a good start. So, Margaret, where is your PowerPoint going to?
It's going to be projected on the wall there.
Okay.
Are you ready for me to turn it on?
Sure. Yeah, let's just go right to it.
I can see people. I love you.
Both
of you.
So please feel free to move around anywhere you like in the room where you can see it.
How the lights work with the lights on, or do you need to shut them off?
And also, Andrew, you just,
It will get brighter as the projector warms up.
all right.
Can I ask a question before we move ahead? So one of the things that's in the statute is support for the group. Can you supply to me the names and the contact information for this?
Yes, we will do that.
All right.
And also, I think in terms of this presentation, Senator Lyons, you'd like to have questions from the working group first at the end or during, and also questions from the public?
The question of when is up to you. So if you would prefer to go through and have us jot down our questions, we can do that. And then we'll go to, so it's either it's your choice.
I often find it most useful to go through it first, because often a question can be answered by a slide that's coming. So if that's okay.
That's good.
And then the slides are, well, you can't see the numbers on there, but you'll have general topics. talking about our membership and charge, much of which we've gone into already, but as well our history, how things work now, how things have changed, and concerns we have heard, and improvements that are underway that some people may not be aware of. It's Section 15 of Act 174 that required that we be specifically constituted, as shown on this slide, the board, the Public Service Department, the judicial officer, and the House and Senate elected member. And I've gone through the charge, which is on your agenda. I thought it might be helpful to go first into a little bit of our history. We've been around a long time, since 1855. I think that many public service commissions were first created to regulate railroads and the like, those being also statewide infrastructure. But if you just look at some of these bullets, you'll see that there have been various points at which our judiciary-like procedures have been brought into play. And, you know, our procedures are both judicial and informal, you might say. But the judicial procedures have been shaped by various requirements along the way, including using the Administrative Procedures Act and Vermont Civil Rules of Procedure, Rules of Evidence, and so forth. And I just bring that up to point out that there are judicial frameworks for much of what we do, especially and importantly in contested cases. Here you can see, since 1997, some of the new legislated areas that have become a big part of our work, including net metering, the statewide efficiency utility, and other programs, speed, standard offer, that have become an increasing portion of our work. Most recently, the Renewable Energy Standard, which is Vermont's equivalent of a renewable portfolio standard, but more complicated because it covers all forms of energy, not just electricity. And we're in the middle of the rulemaking for that standard. So, can everyone hear me, by the way?
Yes.
Great. So the board consists of a full-time chair and 2 part-time board members, all of whom are appointed for staggered 6-year terms by the governor through the judicial nominating process. Our staff includes attorneys, financial analysts, an environmental analyst, and an engineer. Most cases are assigned to a hearing officer who presides over the case and prepares a proposal for decision for the board's consideration and our ultimate determination. But in cases heard directly by the board directly issues our decisions. And we are funded by the gross receipts tax, not the general fund. So we do have a very wide range of proceedings. We'll get into that a little bit on in this presentation. Not just siting and construction, and that's become an increasing part of our workload. By the way, telecommunications, in that first bullet, we regulate the siting of telecommunications towers, but not everything having to do with telecommunications. Of course, there's a lot of policy implementation that comes from the legislature. They'll decide that the program needs to be created, and we are often the arm that creates the details of those programs. And they can be financial, they can be procedural, but they are meant to implement the policy set by the legislature. And of course, like all public utility commissions, rate making is a lot of our work. Anything related to our regulated utilities, from rates to service quality, and even just the authorization to provide different kinds of services, which in Vermont is taking more than just simply the delivery of electrons. So most those are, that phrase is as defined by the Vermont Administrative Procedures Act. One example of a contested case procedure is Section 248 proceedings. And by law, such contested cases are required to follow a trial-type process, which includes the opportunity for evidentiary hearings in which the witnesses are under oath and subject to cross-examination. Probably Judge Mello is the most familiar with this type of environment. Our decisions are appealable to the Vermont Supreme Court by formal parties to each proceeding. And going to the third bullet, we also have the authority to promulgate rules on utility matters, and we're charged with administering certain programs like the net metering program, standard offer program, and the energy efficiency utilities, not just Efficiency Vermont, but now Vermont Gas is an energy efficiency utility, and Burlington Electric has its own territory to provide those services. I thought I'd focus first on Section 248 proceedings because they are the most complex. But there are different kinds of 248 proceedings, and that complexity varies depending on how big, basically big and complex the project is. I'll start with the most full-blown Section 248 proceeding. When determining whether to grant a Certificate of Public Good, or CPG, for a proposed project, we first have to determine whether the project meets 11 statutory criteria. Those criteria were established in Title 30, Section 248, that's why they're called Section 248 proceedings, and they include site-specific environmental criteria incorporated from Act 250, and also general issues such as you can see in Bullet 2, including orderly development, and I won't read it to you, but you can see them in Bullet 2. In reaching the overall general good requirement, we are not limited to those 11 criteria. Continuing with Section 248, full proceeding. Before somebody files a petition to the board to build a facility in Vermont, the petitioner has certain requirements. They must submit plans to the municipal and regional planning commissions no less than 45 days before applying for a CPG. That is, unless the planning commission waives that requirement. And then the planning commission may hold a public hearing on the proposal and makes any recommendations to the board and to the petitioner at least 7 days before the actual application is finally filed. So this is all pre-filing the application. The petitioner then files that application or petition at the board with supporting testimony and exhibits, with copies to the Attorney General, the Department of Public Service, the Department of Health, the Agency of Natural Resources, Historic Preservation, the Agency of Transportation, Agriculture, and the local and regional planning commissions, and the legislative body, for example, the Select Board, for each town and city where the facility would be located. Notice that that petition must also go to adjoining landowners with certain required information. And then, once a docket number has been assigned, the board holds a pre-hearing conference at which it sets a schedule for a site visit, a public hearing, deadlines for motions to intervene, discovery, pre-filed testimony, evidentiary hearings, and briefs. And parties receive copies of all materials provided to the board as part of that docket. Turning to the middle of those lists of bullets, the site visit is not required, but it is usually held because it is important to get a better sense of possible impacts of a project. And those site visits can be conducted either by a hearing officer, most commonly, or by the board itself. Those, anything that we learn at a site visit is not part of the evidentiary record, but helps inform us as to the context of the case and helps us better understand it. Then a public hearing also is held in the county where the project is proposed, and comments are transcribed by a court reporter for later reference. They become part of the public file, and they're posted on the board's website. And the public is also encouraged to submit written comments by mail or email. They don't have to attend that public hearing. And like the site visit, it's not part of the evidentiary record, but the comments often serve to alert the board to issues that the parties may not necessarily bring up. And we also hold public hearings in cases of significant public interest and also when they are not required by the statute. A couple of bullets down, discovery. Those are written or oral questions that provide an opportunity to ask parties about what their witnesses have said and the exhibits they have provided. Evidentiary hearings are very much like a trial, using the procedures outlined in an earlier slide, except that the testimony is pre-filed in written form and entered into the evidentiary record under oath. Witnesses also testify under oath and may be cross-examined by the parties and questioned by the board. The hearings are transcribed by a court reporter for later reference and posted on the board's website. Briefs can be filed at the close of evidentiary hearings. They provide the parties a chance to cite pertinent facts from the record and generally explain their position for the board to consider in adopting the final order, which leads to the last bullet. The decision must be based on the evidentiary record with findings of fact under the Section 248 criteria and conclusions of law. On the right-hand side of the slide are some of the collateral permits that also need to be acquired by the petitioner. They relate to flood hazards, river corridors, stream alterations, and shoreland protection, among other things. And they also provide opportunity for public engagement. So that's the full Section 248 process. Simpler projects receive more streamlined processes. For example, 248Js, they apply if the project is found to be of so-called limited size and scope. If they do not raise a significant issue under the 11248 criteria and the public interest is satisfied by the 248J procedures, a project of limited size and scope can receive an order without the board holding public or evidentiary hearings. A 248K allows the board to waive for a very limited time the requirement for a project to obtain a CPG. This would be in the case of emergency conditions, like the failure of a substation component that is necessary to maintain reliability. And then there are simplified procedures for smaller renewables that are not net metering. At 150 kilowatts in size and smaller, the net metering process applies. For renewable projects over 150 kilowatts and smaller than 2.2 megawatts, the law directs us to provide simplified standards and procedures that provide waiver of Section 248 criteria that are not applicable, for example. And then finally, net metering. Act 99, which was passed in 2013, required the board to write new rules for net metering to start next January of 2017. We're in the middle of that rulemaking process, but it looks as though we will retain simple registration for small residential-sized systems and increasing levels of process for larger projects with the potential for greater impact. So, since this is about public access, I thought I'd like you to get an understanding of the various roles parties play in a case. So, first bullet, automatic, or you could call them statutory parties to a proceeding are required by statute to participate as formal parties in a case, and they must exercise the rights and meet all the obligations of the party in the case. And typically, these are designated state agencies, including the Department, the Agency of Natural Resources in cases that involve siting a project, and the Agency of Agriculture. In contrast, the next bullet there are entities that have a statutory right to appear as opposed to an obligation. And so they can appear as a formal party in a proceeding. These include municipalities and regional planning commissions. But they can choose whether they wish to participate as a party in the case. If they do choose to participate, they have the same rights and obligations as all other formal parties. We then, third bullet, adjoining landowners. They receive advance notice, and they can file public comments or a motion to intervene to participate as a party. Members of the public can file public comments or a motion to intervene, and interveners as a world encompass all parties that are not automatic parties. We are in the middle of the net metering rulemaking process, but it does look as though that final rule will include sections that make it easier for adjoining landowners to become parties. Senator Lyon?
I am looking for that slide in my, aha, I went right by it. All right, and
moving to slide 14. Again, so parties to a formal parties to a contested case are the petitioner, the department, A&R, and so on, but also people who have filed for or been granted intervention by the board, such as adjoining landowners or public interest in business groups. These types of interveners must meet certain criteria, such as a substantial interest in the case. Towns and planning commissions can also be interveners. In citing cases, all they need to do is file a letter stating that they intend to participate as a party. And again, all interveners have the same rights and obligations as the other formal parties, and they follow the board's procedural rules. But in a contested case, many believe that the court-like process is necessary to ensure a fair and orderly process for all the participants. Actually, I'd like to go back to that slide 14 just a little longer, getting to the third bullet. Many members of the public routinely participate more informally, and I'm sure we'll hear, I'm looking forward to hearing some experience on that. But venues in which they can participate would be, for example, uncontested cases or rulemakings. Forms of participation include, in those cases, simply attending and participating in a workshop, for example. For example, we've had workshops on how to implement the renewable energy standard, how Efficiency Vermont should operate, how the net metering rule that we're working on should be designed. Or it could be as basic as submitting written comments by mail or email, all of which board members read. And again, such public comments are not evidence in a contested case, but they do help identify issues. Slide 15. Citing, cases that involve citing, continue to expand as a significant part of the board's workload, especially over the past 5 years, and accelerating in general over the past 15. Speaking to bullet 1, 15 years ago we did not track cases separately, so 10% is our best estimate. Most of those cases in the past involved utility substations and transmission line upgrades. That was our work then. Historically, the largest solar projects seeking approval were 2.2 megawatts or smaller, and they were typically projects participating in the standard offer program. But this year, the board has reviewed, or is in the process of reviewing, 7 proposed projects just under 5 megawatts, and 4 more 20-megawatt solar projects that have not yet sought siting approval. Also, 15 years ago, we did not have jurisdiction over the siting of cell towers, and now we are receiving more than 100 applications a year. And to put a little historical context on the net metering applications, just as an example, we received our first net metering application on June 2nd, 1999. And between then and the end of the year, that year, 1999, the board received 17 applications. You can see on this slide, in fiscal year 2016 alone, there were 2,278 applications for net metering projects. So I found that both when I was in the legislature and here that there is confusion among many people. And, what is the difference between the Department of Public Service and the Public Service Board? Especially when it comes to citizen participation, I do think that is confusing for some people. The Public Service Board, as I've described, we're quasi-judicial. We make decisions in utility regulatory cases, and we implement new policy when directed by the legislature. But the department is an executive branch agency. One of its missions is to represent the public interest in proceedings before us. It does long-term planning for the state, etc. The Consumer Affairs and Public Information Division, informally called CAPI, has as a principal role to assist consumers in reaching informal resolution of complaints against utilities. In October 2012, Governor Shumlin formed the Energy Generation Siting Policy Commission. And its charge was to make recommendations on best practices for the siting approval of electric generation projects and the public participation and representation in the siting process. So I thought it was important for us to recall the work of that commission because it's directly relevant to what we're doing. They issued their final report in April of 2013, and in their summary, I put it up on the slide, they called for a siting process that is more open, accessible, and inclusive, while also providing greater predictability and efficiency to ensure that the best, rather than the easiest sites, are selected. This slide turns that around from a positive recommendation. I've tried to pull out, framing as criticisms, some of the specific points that were in the Siting Commission report. And there were more. These were the ones I pulled out that struck me. But that report is also available, and anyone can read through that. I won't read these out loud. These are just examples of some of the things that are in that report. But we read that report when it came out. And in response to that report, and also hearing complaints or suggestions in other quarters, as siting has become more and more of an issue, more and more of our workload over the past few years, we do have a number of improvements in the work that specifically address those complaints. And I'd like to describe some of those so that, again, for context for this working group. First, regarding the need to be more open, accessible, and inclusive, some examples of changes are we're making more information available on our website, and we're in the process of redesigning that website to be more user-friendly. We have new personnel in the clerk's office who have been directed to revise our internal processes for greater efficiency and access with the goal of responding to inquiries more quickly. Board members are going out in the field to conduct more site visits to inform our decisions in response to specific comments. And we're deliberately writing the new net metering rule to make it easier for citizens in towns, specifically, for example, with plain instructions and template forms. We're in the process of designing that citizens can simply fill in to use to intervene. And I'll go into that more on the next slide. And finally, one of the major recommendations of the Siting Commission was an improved website, including an online case management system. And we call this EPSB. And Ann Bishop will explain that shortly. The net metering rule is still in process, but some of the possible, and actually more than possible, probable changes that would make it easier for the public in those cases include requiring applicants to provide more information up front so people can actually envision the project. It'll be easier for a citizen to ask for a hearing. I mentioned the forms that we're going to create so that they don't have to have a law degree or practice to fill them in. And it also includes a new section for anyone who wants to review an application step by step, plain English. We're doing our best so that this is accessible to lay people. Some of the changes we're proposing in the upcoming net metering rule that affect towns, which of course include citizens. Towns are going to receive advance notice of all projects greater or bigger than 15 kilowatts that are not roof-mounted solar facilities or hydroelectric facilities. Those kinds of applicants are likely to be required to file a document that summarizes the comments they receive from towns and adjoining landowners during the advance notice period and provide a response to those comments. We've also used the rule, and I keep saying, I keep trying to use words like would or could because it has not been approved yet, but we do have a final draft. It will include incentives for projects to be built in town-designated areas, incentives for them to be built close to load and on the built environment. And that gets to the Siting Commission recommendation that the best rather than the easiest sites be selected. And I mentioned the last two bullets there, I described those. EPSB is underway. It's going live soon, and our Ann Bishop has been in charge of this, so I'd like to have her explain it.
Thank you, Board Member Cheney. We are getting very close to going live with Phase 1 of EPSB. I know some of you have heard me say this before, and frankly, this project was just much bigger than we anticipated. But we are scheduled to go live with Phase 1 in November. Phase 1 is going to include all the siting cases that the board has. The Phase 2, which is scheduled for second quarter of next year, includes other kinds of cases like tariff filings or rulemakings or other kinds. The goal for EPSB is to make it easier for everyone to do business with the board. It includes electronic filing via our website, electronic document management, case management, and public access features. Citizens and others from outside the board do not need any special software to use EPSB. You'll be able to go right to the board's website and access the system. And EPSB specifically addresses many of the concerns that we have heard about our current processes and the accessibility of information that the board has. Here are some specific examples of how EPSB is addressing these concerns. There will be required fields on the screen when someone is filing something electronically, which will help ensure that filers have provided all necessary information. Cases will be indicated as under review until they are determined to be administratively complete enough to process, and that status will be accessible to everyone through EPSB over the board's website. The board anticipates making that determination regarding administrative completeness within 5 business days for most cases. And if the filing is incomplete, the petitioner will be notified specifically of what is missing. When the statute allows the board this flexibility, we are going to start comment periods after the case is determined to be complete. This will help clarify what the comment deadline is for various kinds of proceedings, which is one of the things that we've heard, that it can be confusing to know exactly when comments are due. Citizens are going to be able to easily access all public documents and case information from EPSB, including the case status, the schedule, information on who the parties are, and various elements of the case.
Can I interrupt to ask a question?
Not now. We're doing all questions at the end, and the working group
We have
will
one
help
more
us
slide.
Huh?
We have one more slide.
Yes, so we'll all be patient.
Great. Thank you, Anne. This is our last slide, and I'm turning to the fact that we do recognize the value in measuring and reporting on how effectively we serve Vermonters. Our new electronic case management system will allow us to collect and report on a variety of data, not just as Anne was describing, but data related to our performance on cases before us. The first performance standard and draft goals relate to our core responsibility to decide cases in a timely manner. And we will include net metering, all types of 248 proceedings, tariffs, special contracts, financings, accounting orders, and telco CPGs in that standard. The second one reflects the fact that members of the public have a right to a prompt response to public inquiries and information requests. And over the past several years, as more members of the public have become involved in board proceedings, the number of public inquiries has increased. We do anticipate receiving fewer such requests after EPSB goes live. Nonetheless, we will hold that up as a performance measure. The third new performance measure reflects that consumer complaints that require hearings take longer to resolve and can be more difficult for consumers to participate in because they are not familiar with the formal procedures. Thus, we feel it is in the public interest for consumer complaints to be resolved without a hearing whenever possible, using more consumer-friendly informal processes. And EPSB will help us track all of this. Thank you.
Thank you. That's a lot of information in a little bit of time. And before I forget it, Judge Mello, are you still there?
Oh, yeah.
Terrific. I'm going to ask you at some point to help us understand what, if any, quasi-judicial procedures exist within the judiciary itself. And if you could sort of flesh out what that means to you in your role or the role of other folks in the judiciary.
Okay, in a nutshell,
You could do it now, or you could bring it back to us at another time. So if you have the answer, go for it.
okay, I think I can do it now, but I can be more elaborate further later. So, quasi-judicial basically means like, but not exactly like judicial. Judicial proceedings provide to the parties the full panoply of constitutional rights, including the right to understand the complaint, exactly what is being complained about against you, or exactly what you're being charged with, the right to raise all available legal defenses and to assert all available legal claims, the right to be represented by a lawyer, the right to present witnesses, examine witnesses, cross-examine them, the rights to discovery, rights to appeal, et cetera, et cetera, et cetera. All of the procedural rights, the Constitution, the statutes of our country afford a person in court. That's what judicial proceedings are. Quasi-judicial proceedings are proceedings that are meant to match many or most of those safeguards, but not necessarily all of them. The quasi-judicial is a label that's used to describe any court-like proceeding that is held outside of a court context, such as in a public service board or other quasi-judicial administrative board proceeding. Those are governed by the Administrative Procedures Act in Title III, and the procedures there are very similar to, but not necessarily entirely equal to what you see in court.
Thank you. That's very helpful. And I guess it reminds us that we may want to take a look at the APA a little bit, just to understand the statutory authority for that. Is that Ann's job?
Well, I'm doing it, and yes.
I'm making it.
Okay, we'll do that at some point too. I think that's important understanding, and just to get a difference between what's quasi-judicial and what's judicial.
And I did cover some of those steps in the
Yes.
slide, but I think it's an excellent idea.
Good. Okay, so unless anyone doesn't want to hear that, I'll be. Okay, good. Terrific. So questions for Margaret from us first, and then we'll see how many there are down the room.
Well, I would.
May I go first since I
Yeah.
have to leave?
Please.
Thank you. The only other thing I would ask for at this point, besides thanking everybody for letting me do this by phone, is could I also please get electronically a copy of the 2013 report of the Energy Generating Siting Policy Commission?
Right. Good. I was going to suggest that we have that as well, so that's a good suggestion. Thank you. Any other questions?
No, thank you very much.
Well, we're glad you're here. Thank you for being here, and when we set up our next meetings, we'll probably have to do a doodle poll, I would think, but we'll see what we can. We want to make sure that you are able to attend as much as possible.
I very much look forward to working with you all.
Good.
Thank you, Judge.
Thank you.
Thank you. Goodbye.
So might I also recommend that we, as long as we're providing the energy generation siting commission report, that we do the solar siting task force report as well.
Sure.
It has some relevance to it, although it builds a lot on the EBS decision. And we can provide that. It's not. I think that is available on the website.
Well, it'd be nice. Do we have a way? I'll save this question for later. So I just want to know if there are any other questions about Margaret's related
Tony, you want to?
Well, I'd like to, what strikes me and has struck me for a long time is that I think what's lost in everything is the understanding of really, and Margaret would start to hit upon it with the history. You know, how did we get to where we are today, and what are we trying to do, and what is the point of the Public Service Board, and what is the point of all of this? And I think more people have to have a better understanding of, or an agreement, or an understanding of, you know, what the future goal really is, before you can map out a plan on how you get there, and then what everybody's participation role is. If you look back into a little bit of the history, we've obviously come out of a period where we had franchise monopoly utilities whose sole role was to serve their customers, provide them with electricity that turns the lights on, and they were responsible for securing or building the generation and distributing it and collecting the funds. And the Public Service Board's role at that point was to just say, well, are they doing it fairly within this monopoly that's there? And that has evolved, as we all know, for better or for worse, in some people's opinion. And it's evolved to not only that we have opened the door for commercial generation to be providing that power, and it's not just the obligation of the utilities to build generation, but now it is open, and that was the whole point of the PURPA Act, more of an even playing field as well. And so that opened the door for private enterprise to come in at any size and any level and anywhere and any shape. And then the state began to shape energy policy, okay, and saying, and to where we are now, where the state's energy policy is, we want to get to 90% renewable of energy. Of course, electricity is not the sole provider of that or participant of that, but it's a large part of it, by the year 2050, okay? So I see that as the general big box that we're in. What we have failed to do, because we probably didn't, is we're not really looking at, okay, how much electricity do we want, or do we need, or do we have to have generated in the state of Vermont? What are the benefits of that in terms of taxes, jobs, revenue, all that stuff, and the type of energy generation, clean, green, and where are the best places to put that to provide the most secure generation, and that we accomplished that, and at what price, of course. But there should be some way to figure out that design. Then the Public Service Board's role is much clearer. Do these projects fit those guidelines? Rather than they're charged, and they look at I think they have to look at each individual project as an individual project without taking it into context of the, you know, where it fits into the whole thing. And until we start thinking about those things, and not just on where the best siting places are for generation, but much more universal than that. And I really can't articulate all the points of it right now, but I've been thinking about this.
That's very good. I think a lot, we have been thinking exactly along those lines.
I would, though, interject that there are certain criteria that do address larger than just the site. For example, orderly development of the region. You have to consider. That there are certain criteria that do address larger than just the site. For example, orderly development of the region. You have to consider interconnection and things like that. But so just to flag those little things.
Go ahead.
So it's going to be a short statement, I promise, but I'm going to build on what Representative Klein was talking about, because I think that what we have learned through all these, in the last 4 years that I've been doing this with the Energy Generation Siting Commission, and then all the heartburn like, things that people don't like. I've come to the conclusion that this really is, it has evolved. You saw the 20 applications, now 20-something, 10, 100 times, the 100 times more applications. The idea of the old utility model where we were regulating a utility to build one or two big generating stations and then the transmission and distribution was necessary for it has changed to a distributed energy model, and I would argue with anyone that that is a better place for us to be. Yet, it has converted this process from more of a just like monopolistic ratepayer advocacy role to a land use, it looks more and more like land use as it goes through, particularly when you have merchant people that are not regulated coming in with what they think should occur. So this is why in the last couple of years I've really emphasized the planning piece of this is what is missing. And the ability to get, if municipalities want to have a real role and regions want to have a real role, the best way to do that is not through a vote. The best way to do that is to actually do a plan. How you would engage in the state's goals of energy, of meeting our energy goals. And we're starting to do that, and I'm actually really pleased and excited about the results that we've gotten so far. And we're going to do all the regional planning commissions, and as a result of other parts of Act 174. And we are going, we're sponsoring and helping towns engage in this too, and doing training and stuff like that. Now, though I'll admit that the horse has gone before the cart, the horse is supposed to go before the cart, right? But the horse did get out of the barn with the cart before we were able to actually load up the cart with all the things it needed. And we're learning from that and adjusting. What I would say is, in terms of this issue about public access to the Public Service Board, as it becomes more land use like related, people feel like they want to engage more like they do at a municipal level or at Act 250 or in a local planning agency, and that runs it headlong into the judicial part of the quasi-judicial responsibilities of the board. I do believe that we should continue with the formal judicial parts of this because it provides facts, it provides cross-examination, discovery, and a variety of ways under oath of keeping people, providing actual information that they're supposed to provide, and testing them on it. That said, I think there are opportunities that we need to then look at of how to make this process perhaps more upfront, more accessible to the public and more informational in a less formal way that feed into that process to make the actual quasi-judicial process more effective. And so I think there's a lot of good opportunity. I think we've made a lot of progress. I think the board has. I think the department has, but there's more to do. And I think part of it is focusing on the administrative aspects of how to provide information to the public in a way that is fair to the parties in proceeding, but actually is engaging people in being able to find out what's going on and when they can participate.
Just for the record, that was longer than mine.
I think
Well,
you're
no,
probably right.
they were equally,
Sorry.
equally.
And I might say,
Luckily, there aren't 15 members of the board.
in response to that, that was one reason I wanted to include in these slides, the fact that we've heard, trying to hear all of these things as well, and that's why in crafting the net metering rule, still in process, some of those things that you named, I hope, are going to be provided in the ways that I enumerated here.
So, and as we look at Act 174, which we will do, so that Judge Mello's question is a legitimate one, where we are with the local and regional planning process, and then what were the issues that brought this section of the bill to being. So you two have had an opportunity, and so I'm going to say that in 2002 or 3, I when Michael Borkin was chair of the board, I asked him to come in and testify about what is it that the board looks at for the Act 250 environmental criteria, which is then when we added that into legislation. That same year, I went to the Regional Planning Commission annual meeting, and I talked about the need for a different type of energy planning. We were not yet at distributed energy, but we were beginning to think about it and changing thoughts from poles and wires to more discrete understanding at the local level of what energy planning is about. And then 2 sessions ago introduced the bill that I think is the basis for Act 174. But that planning in and of itself is not going to resolve some of the concerns that we hear from citizens and that have promulgated this section of Act 174. So I think, that we can't rely on that to solve whatever issue is before us. I think we do have to proceed in understanding how citizens do participate in contested versus uncontested cases and what roles citizens play in those cases. And we also need to understand then, what you're doing in the department. I think I have questions about that. As you were talking, Margaret, you mentioned DPS. Of course, you had a great slide on it, but it would be great to know what you're doing so we can begin to. That would be good.
Another agenda item.
I think that would be good. And then the other thing that occurred to me is that the environmental court has a process for working with folks who are less familiar with legal jargon and not necessarily lawyers. So it might be helpful at some point also to look at what eCourt does with citizens, and whether they have how they work. And I offer that as a suggestion, and let me know what you think about it later. I think we're going to have a lot of things that we want to look at. But I do have a specific question, Margaret, and that is on page 13, I think. Let me make sure it's on page 13. Slide 13. Yeah, so you've got adjoining landowners, municipalities, members of the public, parties to a case.
Just a sec, I want to make sure the slide is up there or you all, not everyone, does everyone have a copy of the slides? Okay, never mind.
Yeah.
Slide 13,
yeah. So if I'm an adjoining landowner and I want to be involved because there's a big project going on next to me. It could be telecommunications tower. It could be solar. It could be wind. When I ask to intervene, how much does it cost me to do that?
I'll turn to one of our lawyers.
I'm sorry, the question is how much it costs?
How much does it cost me to do that? What do I have to do to be a party to this thing that's going on?
You have to file a piece of paper that addresses the rule right now for intervention. And I'm not sure I can...
Could you state your name for the record?
Of course, June Tierney, and I serve as the General Counsel for the Public Service Board.
Thank you.
The Senator, my guess is that the cost ranges from very little to medium to a lot. It depends entirely on how the person goes about doing it. But what does it need to cost? I can say it needs to cost very little. It basically comes down to getting the rule, looking at it, seeing what has to be answered under that rule, and then letting us know in writing.
Okay. Does the board in any way support the person who's intervening? Is there any, would that be through the department? How does that happen?
I think that's a wonderful question. My understanding from speaking with our clerk, who was with our agency for 50 years, but who has retired as of January, was that she spent quite a bit of time talking to people who would ask questions. They would call her office, that's the first instance, and they would ask about how to go about that. And then she had her way of telling folks, well, I can't give you legal advice, but here's roughly how it works. And that worked to differing degrees with people. but there's no one person whose formal assignment is to take that call and say, let me help you through that process. And then in turn at the department, I think Jeff could probably speak to that more, although I did serve at the department for several years before I went to the board. Generally speaking, in the public advocacy division, and you'll correct me, Jeff, the position is that those lawyers serve the public interest and therefore cannot individually advise a person who would call asking for help in filing for intervention. So I won't say any more about what the current practice is right now. But to be perfectly clear, though, it should not and does not require legal advice to file a notice of desire to intervene in order to convey your thoughts about wanting to participate in this process.
So I think we're getting to a place where we're going to have to listen to a lot of testimony.
Yeah, and I think that there should be, in my opinion, an opportunity to hear how people have actually experienced that process
Yes.
at a future meeting.
Yes.
However, I would add that we have heard informally that it can be confusing, and that was one reason that we are planning to create templates that people can simply fill in.
That's right.
That will guide them through the process, name, etc. So that they don't have to read some complicated rules and think, for example, they may need to hire an attorney to help them through it.
Exactly.
We're hoping that we can create essentially forms that will do the job for them.
That's right.
I don't know, how much you want to get into this?
I think it's a topic that we're going to put on an agenda, but I just wanted to get a flavor
So
for
I
it.
think that, maybe to answer your question, as I interpreted it, like, there are no fees to be paid, but there's always time.
Right.
And then there's professional understanding of what's necessary. So to the extent that you involve an attorney who knows this stuff and or is familiar with 248, that will make your job easier, but it'll cost you more money, right? We do, at least we have in the past, when we were doing it more, we're trying to distinguish between substantive public positions of like what's in the public interest versus helping people with the procedure. So we will talk, even if somebody's opposed to a project that we're supporting in the public interest, we will help them understand the process as best we can without giving them legal advice. There's a boundary there that we should explore because sometimes if you're telling somebody what you recommend in terms of procedure and how they proceed with that, they might consider that to be legal advice as to how they should, do their case, and we can't have that. So that's a tension that we're trying to figure out. And again, going back to the Energy Generation Siting Commission report, they recommended an ombudsman of some sort in the Public Service Board that could actually speak to those type of procedural things for people, because that's where, it's their process. So we should answer that. And then also, there's a lot of discussion in that report about intervener funding, which I think is probably, it sounds like a subject that you might want to look into.
June, did you want to add one thing? And then,
Yes, this is something that has been on my mind for many years as I've listened to discussions about this topic. I just wanted to put it out there. It connects to what Judge Mello was saying about the full panoply of constitutional rights that are served in this process. The intervention request, motion, whatever you want to call it, also has the function of letting the parties in the case know what that person wants to do by way of participation. So it's a notice function, which is why the premium has to be on it conveying what that person wants to do. So there really needs to be some thought given to how to make that workable so that the citizen is not burdened, and at the same time so that the other parties in the case understand and can prepare their cases accordingly. It's a constant juggling and balancing act. Otherwise, what you can do is have many people come in and participate, but if the parties in the case don't have what they would consider to be fair or adequate notice of what that person wants to do in the case, then that gives rise to claims on their part that the process isn't fair.
So I want to, again, talk about simple misunderstandings that we, or that many of us may take for granted, that a lot of people take for granted, that maybe the general public, and maybe a lot of us don't really understand. It's my understanding, and somebody please correct me if I'm wrong, but I've gone on this understanding because when I originally understood it, way back years ago, I didn't like what I understood. But a permit process, and the CPG is a permit process, so a permit process, whether it be Act 250, whether it be a town permit process, the applicant, there's an understanding that you're going to get your permit. And the process is about making sure that you meet all the standards and jump through all the hoops that are in place to make sure that the project itself meets all those standards. And if it meets all those standards, then it gets its permit. It's not really about I like it or I don't like it at that point. There are other venues for that. And I don't know how many people, I don't know whether we're very good at reminding folks about that, because that would have a lot to do with helping the public better understand the process and how they can better participate in it, number one. Now, CPG is a permit process, certificate of public good. Is that definition changing because of the nature of what we're doing has been evolving? I don't know the answer to that. It's not, it was simple 25 years ago. The Green Mountain Power or CVPS would come in and say, we need X amount of more power, and we're either going to contract it from this one over here out of state, or we're proposing to build it. And the Public Service Board could easily look at it and say, yes, they do need that amount of power, and what's best for the ratepayer is that they don't build it because they can buy it cheaper somewhere else. But that's changed. And so does the definition of the CPG change in itself, and how does that impact how the public gets to play more of a part? I think what we have failed miserably on is that we have not helped because the public understand, because many of us don't understand just what the hell we're doing in terms of how the process works. And I hope a key part of this group is to recommend how we can create real information that's really easy for the public to understand, so they get better informed, so that they can better participate to make everything better. And I think that's what's really lacking.
Okay.
I'm done.
Any other questions from the working group on the presentation? So now, I know that there are folks around the room who have questions, and you've heard us ask our questions, and they haven't been questions, they've been comments. I did ask one.
I do actually have a question.
Oh, good, okay. Then I'm going to set my rule about questions from the audience. Go
There you
ahead.
go, very good. I'll try and behave and interact. So can you explain, Margaret, how the board decides whether to grant intervention status to a party in general?
Yes, there are certain requirements that need to be met, and they are set forth in our decision, and questions that have to be answered in the affirmative. So, June, would you be the best person to decide?
I'm happy to talk to you if you like.
Do you want to do that now, or do you want that all right now, or do you want to?
Depends how, is it a short answer?
Is it short?
I can make it real short, yes.
Good, let's do it. Then we can decide if we want more.
So intervention is governed by a board rule. The intervention is filled out, we hope, according to that rule. And then one looks at that, and the board decides, have the criteria been met for intervention? And if it's a hearing officer does it, they're the ones who do it. And the process envisions that there will be liberal understanding of what's been filed. So you look, is this good enough? And then usually an order is issued that explains whether intervention has been granted or not.
Jill, could you go through the 3 questions and have them answered in the affirmative?
Off the top of my head, I'm afraid not. But basically what it comes down to is, do you have a substantial interest? Can you tell us what that is? Can you tell us whether you're going to be able to do this in a way that doesn't slow the process down for other parties? And the third one, I'm sorry, it's escaping me.
Prejudice will not unduly prejudice.
Right, that would, right, exactly. Meaning, unduly prejudice is legalese for, can we help you, participate in this process without it making it unfair for other people? And that's a very fluid concept, because, for instance, if you get a case going and somebody comes to it later because they've only found out about it later, the board can look at that and say, sure, you've got an interest that we need to hear about. We're glad you came forward. What is the impact on the case to all the other parties if you come into the case at this time? So that would be an example where they're looking at that and saying, it's not going to cause really unfair problems for people to have this person come in, even if they're coming in late. Sometimes it can do that, though. And in those instances, the board or the hearing officer would render a decision saying, I'm very sorry, but it's too late because it's unfair to everybody else.
But
And
I
then,
think that defined interest, that you do need to have a defined interest in the case is an important one.
it is, and particularly in the context of citing, you see, under the law, defined interest can also be very contextual, case-specific. In citing, the landowner who is adjoining has the classic, almost automatic substantial interest in the case. And so that's why our rule actually specifically calls them out to get notice of the project. And by rule, I mean the 248 rule, not the intervention rule. And so that they're aware and they can exercise their opportunity to get into the case to let the board know, these are the concerns I have about the project.
One more question. This is, so we have contested and we have uncontested documents.
That's correct.
And it's been my understanding that in an uncontested docket that the public can access the board at will and talk, because nobody's, they can share information, they can share concerns. I don't think the public knows that really well, because I've been called a number of times to say, you got to do this, as a legislator, you got to do this, and I'm going, and I'm sharing with them saying, this is not a contested docket. You could pick up the phone and call any one of them and have this conversation. I urge you to do that. Do we have more uncontested, or what's the ratio of uncontested to contested? And if the public had a better understanding of participation in uncontested, let's take, for example, the net metering. Net metering going on now, that's uncontested. I was reading stuff, press releases by different groups that were making me scratch my head. And I actually called a couple of groups and I said, did you talk to the board about your concerns about this? Well, no. Why not? I didn't know it was good.
Is the word uncontested, and are those two words confusing, you think?
Yes, I think that they are
If you said
confusing.
open?
I think part of the problem is that the word contested implies, has a negative connotation.
Legal.
As opposed to a legal definition. And when you ask about the proportion of cases that are contested versus non-contested, I think proportionality also goes to the length of time that an issue is before us. For example, in a rulemaking, there are defined steps that the procedure takes, starting with an input through workshops, multiple opportunities for public comment or engagement, and drafts that go through various subsequent processes, including posting at the Secretary of State, having required public hearings, more draft iterations, and finally going to LCAR. This whole process, if it's not a rushed rulemaking, typically takes 18 months.
Right.
And so that is one case, but it takes up a lot of time and a lot of process. So it's hard to say, just do numbers. But if I could ask somebody on the staff to answer that in terms of considering that some of these uncontested cases take 18 months, what would you say in terms of staff time proportionally contested as opposed to uncontested issues?
Boy, that's a good. When you consider that 248s are all contested case proceedings, they take up a lot of staff time. The net metering cases are not right now conducted on a contested case basis. I know I'm about to get stuck in the weeds here, but my subjective sense of this is that the preponderance of the board's work is conducted in a contested case process. I would ask Anne to speak to the issue, though, because Anne is she's the yin to my yang on staff, and she's a non-lawyer. What is your perception?
I would agree, Jim, that the majority of the board's workload is in a contested case, involves contested cases. I think there tend to be certain subject areas where more uncontested cases format is used more frequently. For example, things related to the energy efficiency utilities. A lot of that work, which is policy implementation type work, has been done in uncontested case formats. Most of the siting cases have been contested. Even as June mentioned, even in net metering projects, there reaches a point when the board has to make a decision about whether to hold hearings in the case or not. As soon as you reach that point, the case has become a contested case. So I would say that most of the quasi-judicial or the adjudicatory cases that the board is doing following contested case procedures. Some of the policy implementation cases do not.
And then there's just one other point I'd like to clarify. When Representative Klein was speaking about encouraging people to contact the board in the net metering matter, I understand that to be in the rulemaking context, where you're absolutely right. This is like at the federal government, the FCC or FERC. In rulemaking, folks contact them. If you're talking about net metering cases per se, though, that would not be the case. There we go.
But let me just cite another example, which was, fairly well publicized. I'll say contentious issue. Turbine sound. Okay, the board had an uncontested docket open on wind sound for years. I get it, 2 years, whatever it is.
Still open.
Which meant that any citizen could at any point contact, say whatever they wanted, bring forth any information that they wanted. I know that the public at large didn't know that, because I kept getting calls on some people who I thought would know that because they served in the government for a long time, and I had to say, you don't need, I don't need to do this for you. You can go and make your case to the board directly, not formal, informal, whatever you want. Call them on the phone, write them a letter, write them an email, stop them on the street. That's not known by the public.
And I think another way to look at contested as opposed to not contested, that may be simpler to understand. And Anne started to get there talking about contested, invoking the judicial process. And I think Judge Mello also started to explain that very well, that there are certain rights that need to be safeguarded through a court-like proceeding. So another way to think about it is formal, quasi-judicial, and the other bandwidth is informal, process-oriented decisions, for example, rule review.
Okay, so I know that I think the gentleman over here had a question when you were doing your presentation, was it? So the rule about this is ask a question, and about the PowerPoint. We will have opportunity for public comment, and we're going to discuss how best to gather public comment as we look at our future agendas. So it could be a whole public hearing, or it could be a consistent part of our meeting. So we'll leave that fluid, but right now it's just a question about the PowerPoint.
It was more to Ann Bishop as she was explaining the EPSB, and the EPSB seems to be slanted to the
Can you state your name for the record? Sorry.
Greg Pierce.
Thank you.
The EPSB, as I saw on the PowerPoint, seems to be slanted more in the direction of the applicant, but the intervener, potential intervener, is mentioned. Will the potential intervener get treatment in that EPSB so that they can easily do intervention and understand and follow through?
Yes, thank you for asking me that. There will be a way for interveners to use EPSB to file their motion to intervene in a case. Interveners then would get the same kind of email notification that the applicant would when subsequent filings are made in the case by a party, or when the board issues a document. EPSB has a mechanism that allows parties to cases to have what is called a kind of a My Cases feature, and in that does not distinguish between whether it's an applicant or an intervener. If you're a party, you have that same ease of access to information.
And the templates you mentioned, will those be incorporated into the EPSB?
Yes.
Thanks.
Okay. Thank you. Good. John's next.
Yes, hi. Again, for the record, John Brabant, today representing Vermonters for a Clean Environment. I'll get to the question, but I want to put a little bit of a foundation down, like
About
Representative
20 seconds worth of
Klein.
foundation.
Okay, well, it's going to be harder than that, but I'll do my best. So the foundational premise here, as I understand it, is, for this working group, is that public participation is important to good process, right? I think we all agree on that. And public participation is supported by process accessibility, and things that get in the way of, as have already been discussed, are cost, complexity. But there's a third part that hasn't been discussed, and I wanted to get it on your radar. And I know that I've talked to Representative Klein about this in the past. And that is integrity of the process and maybe follow through. And not to be taken disparagingly, but this is as I see it. The legislature and the Public Service Board and the DPS, Department of Public Service, have shown an incredible expertise at reinventing the wheel. We've had deep experience.
So now you're getting into public comment. So
okay,
I
but
would ask you to save that and ask.
So what is not being discussed here, as of yet? Nothing came up in the PowerPoint, but I think it needs to be appropriately part of it. Is the problem? The problem I'm going to underscore with enforcement. Any regulatory program's integrity is underpinned by the ability or inability to enforce the conditions of its permit. The CUNIN administration got the Uniform Environmental Enforcement Law passed through the legislature back in 1990, I believe. And the title of that act, Uniform Environmental Enforcement Act, is key to everyone's understanding of what they were trying to accomplish, and that is we want everybody treated the same. We want timely and efficient and effective permit enforcement. CPGs are permits, as Representative Klein said. This program, the PSB process, does not meet any of those criteria. So I would strongly encourage, and maybe it's a question I need to ask, will this body, the working group, be exploring that in any depth? And will they be looking at, again, without reinventing the wheel, will they be looking back at the experience that the state has already had with another quasi-judicial body, the former Environmental Board, now the Natural Resources Board, and their bifurcated role, where they are both a quasi-judicial entity, but they also, now through the district environmental commissions, utilize the enforcement resources of A&R and some that they now have in-house to enforce the conditions of their permits issued to the quasi-judicial process. And it's a timely process. It's proven time and again as being an effective process. It's got now some 26 years of depth of experience. And so I'd ask, will this panel be looking at that in any great
That
depth?
was exactly why I brought up the environmental court earlier, and so would lead into that whole process, Act 250 process. So yes, I think that we will try to look at as much of that as we can as it relates to the work of the board. So it's a well-taken comment.
Thank you, Senator.
May I also just add, coming from where I come from, which is where you come from, I see the same hole. The court, the way I've seen the board operate on this is like a court, which is what their role is, and I've seen that where they rely on the parties to enforce, to appeal, or to do something like that. And I just want to acknowledge that I absolutely agree with what you're saying, John, and see the need to have direct enforcement of CPGs, be it in my department or elsewhere, so that we can do that work. And it can be appealed. If people disagree with our enforcement, they can appeal it to the board or then to court. But somehow we got to get to the point where we don't have to start another whole proceeding before the board to enforce the CPG. So,
And again, as I stated, Commissioner, there's that bifurcated role at the Natural Resources Board, District Environmental Commission.
Yes, ma'am. And please, state your name for the record.
Jane Palmer.
We've got someone behind me, too. Couple, okay, good.
Jane Palmer, and we are interveners. And first I wanted to thank you for doing this. I mean, this in itself would have been really helpful about 3.5 years ago. And I think it would be helpful for a lot of people to know what the process really is. And it's misleading to have public in the titles, but not really.
So you can thank Margaret Cheney for that. She put this together and originated the idea for it, so we thank her for that.
I had two questions. First one, real quick. How long is this meeting going to last today?
Well, originally we had thought we'd go after lunch, but I think that we will continue through our work and adjourn sometime shortly after, maybe 1 o'clock, something like that, at the latest.
Okay. My other question is, you've mentioned that
That wasn't about the PowerPoint, but I let you get away with it.
You talked about the public comments and the public hearings, and the comments are read, but they're not evidentiary. And I would like to know why that is.
It's, I'll have our general counsel follow up, but essentially because of the requirements of the Administrative Procedures Act, which defines which bases the decision on sworn testimony and evidence entered into the record. And so because, and also through parties to a case, as though it were a courtroom, so that comments from people who are not parties to the case cannot by definition be sworn evidence or admitted, exhibits. So that's why we can't base our decision on anything except testimony and evidence. However, in the case of the public comments and the public hearing, I'm sorry, not the public hearing, three things: public comments. In some cases, there's also a public hearing, and then a site visit. Those are all factors as opposed to evidence. Factors that may lead us to ask ourselves or parties follow-up questions. Factors that may inform us as to the context of the case. So they're important. but they're not legally evidence, and may get money.
I think that was a wonderful explanation. I won't add any more unless it's helpful to you, Mrs. Palmer, or the committee. I can't add anything to that, Margaret.
And I might just make sure that there is a distinction I'm making here between public at large, and there could be a public person, a citizen, who is not one of the formal agencies, is not a petitioner, et cetera, but is by definition a member of the public because it could be an adjoining landowner. If that person is a party that has achieved intervener status and is therefore a party to the case, that person's comments, that public person's comments, are evidence in the so I need to make that distinction. There could be a member of the public who is a party to the case.
Right, well, I guess my question was like the fact that so many, and specific to this gas pipeline, so many people were opposed to it, but that didn't seem to be factored into the decision. I mean, it was, I guess that's what people are so frustrated about, is that it's supposed to be a public access, and they get up there and they speak in front of a large body, and they feel it's just, you're hearing it, but you're not using it. You know what I'm saying? I mean, that's my question. I don't understand, or how when the Public Service Board got 2,000 approximate comments, 98% of them against the pipeline, that wasn't mentioned anywhere in the findings.
May I speak to that? There actually was a portion in that order that described the public comments that the board received, and it was quite detailed. I drafted it.
I was not on that case. I was
You were
on the
not.
board then. So June needs to speak to this.
Yeah, and I don't mean this in any way as pushback as much as I'm just clarifying that those comments, in fact, did inform questions that were asked during the proceeding.
I don't want us to get into individual cases.
Precisely.
I think we all feel the same way, but at the same time, there are lessons to be learned.
Absolutely.
And help us understand how information is used. So what I'm hearing you say is it provides a context, and under the new Act 174 process, if municipalities, a set of municipalities or a region were also against, that would be taken into consideration under Act 174 as part of the evidence or not? We'll have to go through 174.
I think that's a good idea. I think
that, we'll go through 174.
I'm looking at you a little blankly because I don't remember exactly what's in Act 174.
We'll
and has
work
not,
on that.
one part that has come into intersection with the board immediately is this working group. And so I think that it would be useful to have an examination of what in Act 174 will affect what we're talking about. And I've started to, for example, it could be similar to what I started to go into, how Act 99, how we've used the opportunity of the net metering rulemaking to address some of these issues. And so there must be parts in Act 174 that, as you started to describe, bring municipalities into a bigger role. So I think that would be all part of the context we need to look at, so that we're not just looking at the world as we knew it, but as the world as it's evolving as well.
Right, which is always fun. So we have other questions back here.
Yes, and that's one question for Ann on EPSB. In my work assisting citizens and participating at the Public Service Board, I encounter a lot of people who have no computer literacy. They might have an email address, but even that, they don't know how to do anything. How is that part of our population going to be addressed? And I do have to say that one of the bars to public process is parking, and I have to bolt to go put money in my meter or actually move my car, and I think that's a serious issue for access. So,
The short answer, I would say, is the board is going to continue to accept public comments in paper, even after the implementation of EPSB. If there is a party to a case who does not have access to a computer or does not have high-speed internet access, the board will continue to allow that person to participate in proceedings in paper, and that person would get paper copies of things, and that person would file in paper, and parties would have to send that person paper copies of what they're filing.
So initial notification will still be by paper?
Yes, and there are also other times when initial notification is going to happen in paper. For example, adjoining landowners are going to have to be notified in paper because there's no way for an applicant to get email addresses for adjoining landowners.
So will the new materials include information for people who can't or don't know how or don't want to use EPSB? Will that be part of what goes out now in the notice? I think it should be, in other words. I think there has to be a separate new
That's a good
language.
point. Let me make a note of that. Thank you.
Who's next? Okay, yeah.
Wait,
You want me to?
before, sorry, but were you suggesting a break?
As soon as this question is
Okay.
asked and answered, then we'll
Sorry.
take a quick break.
Yeah.
Okay. Keith Ballack, I'm on the Sheffield Planning Commission, I chair it. I have a question that's kind of troubling here. I mean, this is public access to the Public Service Board, the PowerPoint. And the record shows, you know, my observations that several people at this table has taken some pretty large contributions from the renewable energy industry. And I guess my question is, do you see why there's an appearance of conflict of interest here? I mean, can you really rule objectively? Can you?
So I'm not clear what your question is.
Well, my question is, can you be objective with the record of you taking money in the past from the renewable energy industry and in your legislative records? I mean, we just talked about a little while ago about the environmental court that a couple of you at this table helped remove from the process a couple of years ago. Now you're talking about maybe that should have been back in there. Can you objectively help with public input? I mean, can you be objective? I mean, I think it's a fair question.
Your question is, do any of us sitting at this table have a conflict of interest? And you're talking specifically about
The appearance. There's appearance of a conflict of
appearance
interest.
of conflict of
Yes.
interest. Well, I would answer that I can be objective, and so we'll go through the charges before us. I am a citizen, and I'm elected to represent my constituents, and I represent them all, not just one group.
Not just the donors.
And never have. I've got probably the least number of donors in the history of the Senate. So you can raise your concerns. And
anybody else? Like
Sure, I will. I'm not running again, so.
We know that.
So I'm retiring, so I don't know how that factors into your equation. And if I'm thinking back on donors that I've had in the past in the renewable energy game, I don't remember any donor being any more than $200 or $300, and I do know that I have taken donations from constituents in my constituency that happen to oppose wind.
Check the Secretary of State's website for that.
Okay.
yeah,
Appreciate your
you
comments.
should look. You should look. Very good.
And I've gotten no donations from anyone.
Okay, that's nice to
And
know.
I can't remember the last time I got a donation.
So good. All right. Are there any questions about the power plant?
Yes, I want to raise it.
Sure.
My name is Ed Ripka. I'm from New Haven, and as I said, I was an intervener in a Section 248 proceeding, still am. My question relates to page 7, where you discuss the PSB structure. And you have the board members, you have a legal division, policy division, and financial analysis division. Are all these individuals actually employed by the Public Service Board as opposed to the Department of Public Service?
Yes.
Okay.
The only people I mentioned on here were board staff.
Okay.
And just for the future, I mean, if you were interested, I could certainly fill you in on our staff, the parallel.
Well, my question really is, what is the relationship between the Public Service Board and the Department of Public Service? I think the public perceives really as these two entities as being two arms of the same entity, and in fact, the Department of Public Service is perhaps the workhorse of the Public Service Board because it does all the background work and collecting all the information and assimilating it. So what is the relationship between the board and the department?
Commissioner Reggio, would you like to take that question?
I'll take it first, but
Okay.
please do, I'm interested in the board's answer to this as well. I think I know that. So the Public Service Department is charged with representing, in the case of rate cases, in other words, money, ratepayer issues, and in case of overall projects, and a lot of which employees are deciding ones, the public interest. What is in the public interest considering the statewide public interest? And then we do analyses, particularly on the money, on a tariff or a rate case. We have economists. We do a lot of analysis as to what the utility is saying they need for to run a strong and functional utility. But in a monopoly situation, we often do challenge those aspects of it. What we do is put together our testimony, be it on a rate case or a siting issue, of what we think is in the public interest, where we think the issues are, and we present them to the board. We're then a witness in the case, a party in the case, and all our witnesses are cross-examined and subject to discovery and all the other things for both the applicant and the interveners. Then, we come into the process and answer questions that the board may have or things that they want us to brief about. But it is the board that is making the decision. We are coming up with an interpretation of what we think, sometimes what we think the decision should be, and we're presenting that to the board, but it is subject to challenge and obviously, in many cases, subject to not the board agreeing with us. So.
Yeah, and I would go a little farther than that because, again, it depends on whether we're talking about the world of contested cases or the world of other. And in a contested case world, the department is a statutory party, and there's the same formal wall between the board and the department as there is between the board and any other party of the case, including the petitioner. So there is no informal communication. Everything is in the form of pre-file testimony and briefs. They appear as a sworn witness if it's during the evidentiary hearing, and they participate in that manner.
So the board staff...
Our general counsel can add.
I'm the sort of resident historian for the day. There actually was a time when the two were together, and that's on the slide. That was in the 80s and before. And then they were separated. I'm not sure I can tell you exactly why they were separated. I have a variety of memories about it from research I've done. But the bottom line is there was a very conscious decision to separate the two. In many respects for the very reason Board Member Cheney just said, because in a contested case there's a wall, and there is no communication across that wall between the department and the board. I hope that helps answer your question.
So the staff of the department is separate from the staff
It
of
is
the board?
indeed, yes.
Because I think the public perception is not to that effect. I mean,
Yes.
like when we are intervening in a proceeding and we are going before the board, I feel that we are asking the board, and if we are disagreeing with what the Department of Public Service has done, I feel we are asking the board to basically overrule itself, that it's going to overrule the Department of Public Service, because after all, you're all located in the same offices. You deal with each other on a daily basis.
That's actually not necessarily the case, but this is Madam Chairwoman's call, but I think it would be very helpful to this committee to better understand the origin of perceptions like that.
And there's a lot of reason for that. In other parts of the country, there is the PUC, the state PUC, the Public Utility Commission, and then they have a consumer advocate arm, but they're all the same entity. Here, for reasons I don't know historically, they've been separate. And I think because there's literally one word difference, you know, the Public Service Board, the Public Service Department, it's immensely confusing to the public. And I'm not surprised you're confused. And indeed, because of that, you know, in a contested case, that separation that I talked about, it may be perceived, nonetheless, and in spite of that separation, it may be perceived the department is voicing opinion in their briefs that we necessarily follow. But believe it or not, we don't always agree with the department. And we do take their pre-file testimony and their briefing as we would any other party.
Maybe if I could just emphasize the point that you about emphasizing the law of June to the student. We are very, very strict about not any contested case. There are no conversations between our staff and their staff that aren't in writing and directed to all the parties at the same time. So, you know, it's just a fundamental structure.
It'd be interesting discussion. Should there be more different needs?
Well, the recommendation I would have is that this is something that, you know, really should be clarified so that the public understands what the distinction is between the board and the Department of Public Service.
Absolutely.
And that's why I had those slides up, because I do think that's an issue.
And I do have contests going on in my department for
For a new
someone who
name?
can come up with a new name.
I just wrote that down.
Yeah.
That's good.
Yeah, because
Okay.
there are better ways to distinguish this.
All right, well, let's take a 10-minute break, and then we'll come back and finish up our agenda. I think if the public has additional comments, we'll entertain additional comments from folks, because it is on our agenda. And we'll be talking about our next steps and what we'll be looking at. Because this is a working group, and it is structured as a legislative committee would be structured, we won't be taking public comment at each meeting. But what I'm going to suggest is that we have the public hearings. For those of you who are in the room and you have a consistent interest in this, we'll try to make it as informal as possible at points during our meetings, so we can have this kind of a conversation, because I think that's important. But in terms of having more formal input, we'll design one or more of our meetings to take public comment. So we'll try to do the best we can. So let's take a break for 10 minutes, and we'll come back and finish.
Will there be a place to send, for other people to send comments? Who would they send it to?
So let us wait until we know what our meeting schedule will look like, and it may be that we have public hearings, more than one public hearing, and that would allow folks to send information in.
And where will that be notified? On the Public Service Board website like this one?
We don't even have that answer. I don't have that answer for you.
Okay,
Well,
I can't answer that question.
I think that's a good discussion.
But it's a good discussion after
at
we get that.
12:15. Or 12:20.
12 o'clock. So it is
All right, we have some
12:05. We'll be back here at 12:15.
We just had somebody behind me.
My blood sugar's getting a little low. I'd like to get a sandwich.
Go right ahead.
Rough.
I'm gonna slog on through, so.
Senator Lyon, since you're chair, I guess you're setting the agenda going forward. If I might suggest that as part of a future agenda item, that
So can we hold that
Well,
until after our break?
I have to leave, so I just want to just get on the record. If as you can have a presentation done by those with expertise in the Natural Resource Board role and commission role on enforcement, and they could walk through that process.
So I've already written that one down.
Okay, I read your mind again. I'm sorry.
Okay. Okay, good, thank you.